Hello everyone, and welcome to this second video tutorial on how to apply the law on vicarious liability to a tort scenario. In this video tutorial, we're going to be looking at the Otto and Springfield school mini scenario. We're going to be reminding ourselves what the law on vicarious liability is and looking at the idea standard structure for how to write a nice answer to this. In a previous video tutorial on vicarious liability, I showed you how to use the idea EA structure for answering the Alice and Cracks scenario. But in this video, I wanted to show you that you can use standard idea on vicarious liability, and you can see which one you prefer. So let's start then by having a look at what our situation is. So Otto is employed as a minibus driver for Springfield School. He does not wear a uniform, but Springfield School pay him an annual salary and deduct tax and national insurance. Otto's told that he must only drive school pupils. Otto is driving the school hockey team to a match. On the way back from the hockey match, Otto picks up his friend Mo. Otto crashes into a parked car and Mo's arm is injured. The next day, Otto drives to a concert in the minibus and runs over Bart, who suffers a broken leg. And you're being asked to advise Mo and Bart as to what action they can take in tort. Now, this particular question isn't telling you which tort you should be applying here. Now, what you will have spotted, hopefully, is that Otto has been negligent in both of these situations, because he crashes into a parked car and the next day he runs over Bart. So presumably he's been negligent in both of those situations. So you could apply negligence to this, but the best advice for Mo and Bart is going to be rather that they sue Springfield School rather than Otto, because Springfield School are going to have more money than Otto. So in this particular case, the best advice you can give is that they should sue in vicarious liability. And when you think back to the requirements of vicarious liability, the first requirement is that someone's done a tort, usually negligence. So in this situation, the fact that he's negligent is relevant. So he meets requirement 1, and then we go on to the other requirements. And actually, it might be useful just to go back to the summary sheet for vicarious liability, just so you can see what I'm talking about here. Let's recap then. Vicarious liability is where an employer, in our case Springfield School, is held liable for the torts of another, even though it wasn't their fault. It was Otto who was driving the minibus. And in order to prove that Springfield School should be liable to Mo and Bart, we have to satisfy these 3 requirements. Firstly, a person committed a tort, usually negligence. Well, as I've just discussed, it looks like Otto was negligent. Second requirement is that the person committing the tort was an employee. So they've got to meet these tests here that we've got our cases on for deciding whether they're an employee versus an independent contractor. And requirement 3, they must have been acting in the course of employment when the tort was committed. And this is where you've got to consider, were they actually doing their job just in a negligent way, or were they on a frolic of their own so that the employer is not responsible? So now we've got this fresh in our mind, let's go back to the Otto scenario and see what we can pull out here. So we'll go through and highlight anything that seems to be relevant. Now, first sentence, we're told that Otto is employed as a minibus driver by Springfield School. That's giving you a clue in the exam when they're talking about employment in tort. That's usually an indication that you should be thinking vicarious liability. Now, just because the scenario says they're employed doesn't mean necessarily they're an employee. They could be employed as an independent contractor. So although it says employed, we're still going to have to work out which he is. So just be careful about that. Let's carry on. He does not wear a uniform. Now that's relevant. The fact he doesn't wear a uniform suggests he's not integrated into the organisation, perhaps. But Springfield School pay him an annual salary and deduct tax and national insurance. So that suggests that he is an employee rather than an independent contractor. Otto's told that he must only drive school pupils. So this is telling us that Springfield School has a degree of control over him because they're giving him instructions on what he can do. And that will also be relevant later, deciding whether he was in the course of employment or not. And then it says Otto's driving the school hockey team to a match. So that seems to be okay because he's been told to drive school pupils. On the way back from the hockey match, he picks up his friend, Mo. Sorry, I'm trying to highlight that. There we go. So that's relevant because he's been told he should only drive school pupils. He's picking up his friend. So this is raising the issue here. Is he doing his job in a negligent way? And you've got to consider the cases such as Iqbal on doing work in an unauthorised manner. Or is he on a frolic of his own? Springfields are going to want to say he's on a frolic, so they're not responsible. But that's what we're going to have to determine. He crashes into a parked car, Mo's arm is injured. The next day he drives to a concert in the minibus. Now, we're a bit vague here in the scenario, but it seems like this concert is just a concert he wants to go to in his own time. It doesn't seem to be to do with the school. So he's driving to a concert and then he injures Bart. So this is looking like this is a frolic when he injures Bart, and in which case Springfield School wouldn't be responsible for that. On the face of it then, it looks like he is an employee. And it looks like the first issue where he's injured Mo, Springfield, are going to be liable for that because, okay, he's doing work in a forbidden manner, but he's still doing the job that he's employed to do at the time. The second issue when he injures Bart, that seems like he was just on a frolic of his own, so Springfield wouldn't be responsible for those injuries. Okay, so we've worked out what the issues are. I'm now going to show you on the next slide a bullet point answer for this, and I'm going to show you a standard idea bullet point answer. So it's a bit small on here, sorry about that. You might want to pause the video and just have a detailed read through it before pressing play again. You can ignore the red ones, they're just a rough mark scheme for if we were doing this in class. So you can see here that I've used idea, identified, defined, explained, and applied. So I've identified that Springfield School might be liable under vicarious liability for the injuries to Mo and Bart. And it's always good to point out who your characters are in your identification. In order for Springfield to be liable, I've listed the requirements here. So the requirements are that Otto committed a tort, he was an employee, and he was acting in the course of employment when the tort was committed. I'm then going to explain the requirements of vicarious liability. So for vicarious liability, the tort is usually negligence. And then I'm going on to the next requirement, the orange bit. We have to decide whether he's an employee or an independent contractor. Remember, if he's an independent contractor, Springfield School are not responsible. So I've explained the tests that we would use here using the cases. Mine's just bullet points so you can see what to include, but in your answer you should be writing in full sentences. And it's good to outline what happened in the case as well. And for these cases, for example, the multiple test, ready mix concrete, you must list what the three-part test is for employment from ready mix concrete. Mine's just bullet points, but you're going to explain this fully. So I've explained employee status. I would then explain what it means to be in the course of employment. So I'd talk about cases like Century Insurance. So that was where a guy was filling his petrol tank with petrol, which was part of his job, but he was smoking at the time. Obviously, that's a very negligent thing to do. He shouldn't have been smoking, but just because he shouldn't have been doing it didn't mean that his employers were not responsible. I'd be talking about frolic of their own, authorised work in a forbidden manner. That's particularly relevant to this scenario because Otto was told only to drive school children, and yet he picks up his friend Mo and he goes off to one of his own concerts. I'd explain travelling to work an unlawful act as well. So I've got a chunky E, and then I'd go on to my application here. In the previous video, I explained employee status, applied it. Explained course of employment, applied it. You can do that if you want to. Okay, this is just the other option. Explain it all, then apply it all. So if we have a look at my application, Otto's committed the tort of negligence with his negligent driving. And if we were doing a full scenario here, i.e. not just looking at a mini scenario, you would do all of the law on negligence first of all, and then all of the law on vicarious liability. Then I'm going through whether I think he's an employee or not. So Otto has no uniform, so this doesn't seem to meet the integration test from Stevenson and McDonald. But he does seem to be under the control of Springfield because they pay him, they deduct national insurance, and it seems it's also sufficiently close to employment, as in the cases of Cox and Aslam. I've also applied the three-part test from Ready Mix Concrete. So I've said that Otto provides skill for a wage. Springfield has some control over him because they tell him he should only pick up students. And there's nothing inconsistent with employment. It's really good to apply this test. You're going to pick up good application marks for applying the three-part test to your character. So I've explained employee status, and it looks like he's an employee. I'm now applying course of employment. So I've decided here that Otto's acting in the course of employment when he picks up Mo, even though he was told only to drive pupils. And that's because he's still doing his job, albeit in a negligent way. And you could apply Century Insurance, Rose and Plenty, Limpus, all of those cases support that point. And it'd be useful here to outline what's happened in some of these cases. So, for example, in Rose and Plenty, the milkman was told not to allow school children to jump onto the milk cart and help him deliver milk. He ignored that and a child was hurt. The employer was still vicariously liable even though he'd been told not to do it. So that is just like what's happened with Mo. And it's good in the exam to say this is similar to the facts of Rose and Plenty, because that shows the examiner that you really understand the case. I've just listed them here, but if I was writing it out in an exam, I would have outlined what happened there and compared it to Mo's case, and I'd be picking up really good application marks. And then considering the next situation with Bart, Otto's on a frolic of his own when he runs over Bart because he's going to a concert. And again, you could compare that to the facts of Story and Ashton. That was when I think they were delivering wine in a horse and carriage. It was a very old case, and they went off on their own business. So that was similar to what's happened here, and that was held to be a frolic, and the employer was not responsible. So our conclusion here is quite nice and straightforward. Otto is an employee. So Springfield are going to be responsible for Mo's injuries that were caused in the course of employment, but not for Bart's because he was on a frolic of his own. As I say, you would want to write more here, full sentences, but this is just so that you can see what we'd be putting in to this answer. So I hope that's been helpful on how to apply vicarious liability. Remember, you can use the standard idea I've used here, or you can explain a bit, apply it, explain a bit, apply it. Either way, you're still going to be getting the same content into your answer, but explain, apply does have the benefit that if you run out of time in the exam, you've not lost all your application marks, because if you run out of time, that's the last bit, isn't it? Whereas if you're weaving your application in, you're always going to be picking up both types of marks. So I hope that's helpful. Have a go at both idea structures on this.